Hi, I'm Mark Westcott, once again with Peter McKnoulty, consultant with McKnoulty in Brisbane, one of Australia's leading law firms. Pete, one of the final questions for this series is, I guess, in regard to what we do ourselves, strategic evolution and the peace of mind plan, which we've taken many clients through in the past. And we touched on this in one of the earlier sessions, and that was the importance of a facilitator. And occasionally I speak to people who say, oh, that's okay, we've sort of got everything taken care of. My solicitor down the road who's done our conveyancing and does some of our corporate work and so on. Look, he put a will together for us a couple of years ago, and so we think it's all sort of taken care of. I guess what I've found in my experience is that the facilitation role is one about asking all the right questions, and sometimes it's a bit like going and looking at the fact that often people get into a rut in regard to how they process things, and occasionally some people may have very firm attitudes in regard to how they think wills should be structured, and they may be oblivious to some things that it's what we call the unaware squared trap. Sometimes you don't know what you don't know. So I guess my question to you is, and that was a long-winded way of getting to it, is what do you see as the strength of having someone to facilitate the process and to ask good questions before the client gets to you?
I think it's extremely important, Mark. From a number of aspects, the key is you don't know what you don't know, and that's what I find is when you have a team of advisors who know each other and are used to working with each other, they know the questions to ask, and that's because there is someone, a facilitator, and I've done a lot of work with Mark over the years. If we have a facilitator who knows what questions to ask, then the information is provided to the lawyer and the accountant, because I'm a firm believer that the exercise needs to be one which involves the accountant. As I said in one of our earlier sessions, the will is the final part. I almost said the final nail in the coffin, but I shouldn't put it that way. The final part of the estate planning exercise, because there's a lot of other issues that need to be addressed to put the will in its context and its right place. So the facilitator plays a critical part in that. From my perspective, if I have someone like Mark who provides me with the information which Mark knows I will need in relation to the client, I can be much more efficient and therefore much more time effective and therefore cost effective, exactly, for the clients. Sure. If I've received information in advance. So I can find if I get good information, and it certainly happens on a regular basis, if I get good information in advance of the meeting, I can look through that, and in 10 or 15 minutes I can understand 85 or 90% of the issues before we sit down to the meeting. And so you can hit the ground running in that meeting, so it saves time and it saves a lot of stress, because I've had other situations where I've had clients come in and you spend the first 90 minutes extracting information, and it's a very painful and a very expensive process, and I frankly don't need to be involved in that process. I prefer to digest information which has been prepared by the experts, and so that I can offer my value. That's right. I'm good value at giving advice. I'm not much good value at taking name, rank and serial number.
That's right.
So no, it's a critical part of the exercise.
Okay. Thanks, Pete. Once again, thanks for being involved in this whole series, and look forward to our next series with you in regard to further issues concerning estate and business succession matters. Thanks for your time.
My pleasure.